The light turns green, and here we are. Good afternoon, everybody. Thank you so much for joining. What I'm referring to is the 18th annual HOA legislative update. And I mentioned the 18th annual. It's because it's the 18th time I've done it. So, with that being said, let's do the housekeeping and get everything going. First, good morning, good afternoon. My name is David Firm, and I'll be your host for this Act for Goodwin's festivities. Thank you for joining us today for, as I mentioned, the 18th annual HOA legislative update, in which we go through all of what the legislature accomplished this year and how it impacts our nice little niche of an area of common interest law. You should, on your screen, you should primarily be seeing the PowerPoint presentation right now, the big screen. You should additionally be seeing a small box on the left-hand side of the screen with the presenter, me, in it. On the right side of the menu, you see a private chat icon. Please use this icon to type in your questions throughout the program. As you know, I typically like to be interrupted because if you have a question, others have a question, I will address those as I go along, particularly before I leave one bill and move on to the next. So that way, at the end of the class, I'm not sitting here trying to answer a whole bunch of said and remembering what I said. And then, of course, questions will be addressed at the end of the webinar, time permitting, assuming I haven't already addressed it. If you have audio or video issues during the presentation, please click the No Audio or Video button below the PowerPoint on your screen and follow the instructions. They probably say something along the lines of turn it off and turn it on. But hey, please follow those instructions, not those of your host. One CMCA credit will be automatically generated and emailed to you within 48 hours after the webinar, assuming you attend the entire program. No cheaters out there. You can't log off and then expect to be logged back on. These credits are not transferable. They go to the email address you've got. Please email education@altitude.law if you have any questions about the webinar or receiving your CMCA certificate, or in general, if you'd like to know how the weather is. Alina would love to answer those questions. Lastly, there will be a survey that will pop up at the end of the webinar. We truly appreciate your feedback you can provide. Your thoughts and opinions assist us with improving our future presentations, so please don't hold back. And if you're really, really nice, you may never see me again. I mean, you'll get to see me again. So with that being said, how's everybody doing? This was the 2024 legislative season. If you recall and attended the 17th annual HOA legislative update, you remember at the end of that I said, my friends, with the HOA task force being formed, I really don't think they're going to do much in the HOA realm as far as legislation this year, because I would think that they were going to sit there and wait for the report to come back. Boy, was I wrong. This year, we were actively tracking 24 bills. Last year, we were tracking 9. The year before, we tracked 8. Actually, it was 27 bills. These bills ranged from housing, evictions, collections, insurance, development, public policy, towing, where you can build, how you can build, and the like. It was really a fun year, if you will. And the legislature lets you know that they love the HOA world and they love to address it. So, what were the goals of the legislative session? And these are Governor Polis's stated goals this year, were to increase housing affordability, to allow more paths for owners or residents to stay in their home, what I refer to as, prevent unhousedness. There really was this effort to stop this influx of people being pushed out of their homes through one way or the other. This involved collection limits and slowing the collection process down. It involved a bill in relation to what they refer to as for-cause evictions only, meaning you can't just evict a tenant from a property you own just because you want to evict them. You actually had to have cause. There were, in that bill, there are a number of procedural remedies for that. So what you really saw is they were trying to tackle the housing prices, housing availability, and keeping people in their homes. They also, for the first time in a long time, I've really seen them try to tackle covenants which they believe to be opposed to public policy. And that's, that's everything found in 106.5, 106.8, or 106.5, 106.7, 106.8. the solar, it's the stuff that they want to push upon the state of Colorado by prohibiting certain actions. So with those goals in mind, buckle up, because here we go. First, the affordable housing bill, or to address affordable housing. SB 2411, actually it's HB 241152. I'm sorry, I did make that typo. That is HB 241152, concerning increasing the number of accessory dwelling units in the state. This bill was over 26 pages. So it created zoning requirements. It created funds to increase the availability of affordable housing by building alternative dwelling units. When it boils down to it, they pushed over $13 million into funds to help municipal entities create uniform plans, kind of a standard template. This is an ADU that you can buy off the shelf and throw up on a lot. As far as we are concerned in the HOA industry, what this effectively does is it prohibits an association from allowing an owner to construct an auxiliary dwelling unit on their property. This really only applies to communities with single-family homes or single-family detached homes, true lots that they have a backyard that they can put it up in. It really only applies to if you have what's called a ADU supportive jurisdiction or an ADU jurisdiction. It's basically 5 areas. It's the entire I-25 corridor, practically all the way from Wyoming, all the way down to Pueblo. So if you're on the I-25 corridor, pretty sure you're in a ADU supportive jurisdiction. It's Denver, Boulder, Larimer counties, Jefferson County, Douglas County, El Paso County, Pueblo, heading on up, heading on down. So the association can address kind of aesthetics of an ADU. It cannot effectively prohibit an ADU or increase the cost of an ADU. So those are off the board. And Lisa, does this new piece allow for an HOA to charge amenity use for residents who have an ADU? Communities are built the amenities to accommodate the number of lots. I agree. They are built for, you have this many lots, this many homes. Technically, theoretically speaking, you could double that number of homes in your community. And they can be as small as 400 square feet, big as 700 square feet. You can, like I said, you can make them match the existing home. So one thing you cannot do is require additional parking for these ADUs. You must not allow for that when these are created or when these built, parking is not a consideration. So in answer to your question, Lisa, specifically is that I would require an HOA to amend their declaration to somehow state we can charge a fee, we can charge an amenity use fee, we can charge some sort of additional fee or additional assessment for each lot that now has 2 homes on it. And additionally, the ADU, a couple more criteria I wanted to, before I forget them, is it must be able to contain complete autonomy. Meaning it's got to have its own plumbing, it's got to have its own sewer, it's got to have its own kitchen, it's got to have its own living facilities. So it can't just be kind of, we throw up a tough shed in the backyard, call it an ADU, and they come in and they use the main house's facilities. No, it must be fully independent living. Charlotte, how much permits affected? That's part of the rest of the bill. There is a streamlined process to obtain these permits. You association cannot prohibit. The governmental entity cannot unreasonably restrict and must streamline these permits. They cannot require any sort of public hearing, which is why the state is throwing money at creating this concept of you have pre-approved plans that if I wanted to off the shelf, just go grab it, throw it down, and it's mine. So I can pull that off. As far as the rest of it, one more question, Samuel. Will water rights agreements overrule HB 241152? Possibly, but the grant program, again, allows or is an attempt to allow people to pay the tap fees. So these are intended to be allowed to be built, period, end of story. And if you have a well decree or if you have a water decree, you'll have to check that because that might not allow additional units because you don't have enough water for it. As a matter of fact, I do know an association in Jefferson County that doesn't have enough water for it. But if you're on city water and city sewer, forget it. They're going to have to be allowed to be built. Mary, can you clarify the HOAs can require ADUs to go through the design review process? They can, but it's a very limited design review process, plus a few more things down the road. I'll show you how truly limited it is. But if it looks like the main house or has the same main house colors, you're not going to have much ability to prevent its construction, period, end of story. Did I hear you say the covenants must be changed to adjust dues to include an HOA? Yeah, more than likely. You right now probably do not have the ability in your particular covenant to address the duplication of units on a particular lot. So if your assessments are like 99.99% of the assessments out there that state it's the assessments are calculated based on a fraction, the numerator of which is 1, and the denominator of which is the total number of lots in the community, you cannot charge an extra assessment for that ADU unless you somehow amend the declaration. All right, so I'm going to move on for this. Save your questions if I don't answer them. I'll come back to it at the end. The next affordable housing bill, HB 24-1007, concerning residential occupancy limits. This is a super cool one too. It prohibits a municipal entity from enforcing occupant restrictions not based on life, health, or safety. As you had stated, or as historically, municipal entities have, like Fort Collins, had the U+2 rule, that you and two unrelated people cannot live in the same unit. That is now illegal. The only restrictions that are permissible for occupancy limits are based on life, health, and safety, demonstrated health and safety standards, meaning they're in a building code, fire regs, or the Colorado Department of Public Health and the Environment standards. That's it. And if you as an association have absolutely no right to enforce those anyway, because those are municipal codes. So what this means to your community is, yes, you could have theoretically 5 to 6 to 8 people living in a 2-bedroom condominium. There's absolutely nothing the association can do about it. So it's one of those things. Again, the goal, going back to the front standard, the goal of the legislative session was to increase housing affordability. This is one of their plans, to increase housing affordability by prohibiting a municipal entity, and as I say, de facto, an association, from trying to enforce an occupancy restriction based on anything other than ascertainable life, health, safety standards. So you are going to start, I believe, owners will start calling and saying, why are there 15 people living in that 2-bedroom condo? And you're going to say, well, because HB 24-1007 prohibits a municipal entity from restricting it. Next. Okay. They went into collections. And as I mentioned, kind of remember, the whole point is to decrease the cost of living in a community or decrease the cost of housing and keep people in their homes. Well, 1337 does kind of both of those. And this, right now, this has not been signed into law yet. So as of this morning, this one was still sitting out there. It has passed. It is sitting on the governor's desk. It was given to the governor with another collection bill, which I'll discuss in just a minute. He signed the other one, not this one. So what that does, I'm not exactly sure. And Danielle, you said you may have missed it, but I apologize. Can an HOA have it written in their documents that no more than 3 people can live in a unit? It can be there. It'll just be unenforceable. Because again, you cannot enforce a standard that the municipal entity cannot enforce. And it is against public policy, statute states, against public policy to have any occupancy restrictions not based on those specific criteria. That's an arbitrary, the 3 people can live in a unit in the HOA, that's arbitrary and it is unenforceable. Okay, so 1337 addresses HOA collections. It caps attorney fees on collection and enforcement cases to $5,000, the half of $5,000 or lesser of $5,000 or half the amount being sought. It requires you to seek a personal judgment prior to going to a foreclosure. It expands the requirements that the administrative provisions that the association must go through prior to initiating foreclosure. Again, this concept of let's slow it down. And Tamara, yes, 1337 also, if signed into law, it will apply to commercial associations. It does not make that differentiation. So it still slows it all down. But what it does, 1337, like I said, it's not signed right now. It limits collection costs, limits attorney's fees, with some caveats that it only really limits those provisions, or only certain parts of the statute apply to owner-occupied units. If it's not an owner-occupied unit, which kind of gets to, you know, your commercial association, if you will, it's the few different rules apply. But generally speaking, it's still the same. Let's slow it down. It requires mediation if the owner wants it. Requires foreclosure notices be sent to all lien holders prior to the initiation of a foreclosure. It increases the list who can't buy the particular unit at a foreclosure sale. The association can, but nobody on the board, or no former board member for over 5 years, no management company employee or an employee of the management company for the previous 5 years, or an attorney, the association's attorney, nor anybody that worked for the association's attorney office for the previous 5 years. So you kind of sit there and see it really does slow life down. It expands certain things. And David, thank you. They had not updated their website. So if 1337 really was signed by the governor yesterday, take off what I said. It had not been signed. Well, like I said, the website showed it had not been signed as of this morning. So I can go back and check in on that. But thank you. So yes, 1337 applies to no, it does not apply to non-Kiowa communities. This is a Kiowa statute. It does apply to pre-Kiowa communities. Can a 55 community regulate guests visiting the community? Oh, come on, guys. That's not even, Ross, that's not on the bill yet. I'll come back to that one. Okay. Are pre-existing collections that exceed the limits grandfathered in? Yes, they are. This applies to future collections after its applicability date. Okay, here we go. Next, 1337 continued. As I mentioned, it expands prohibited parties from purchasing as foreclosed property. I'd say it's all the old parties plus former employees for 5 years, attorneys. Requires notice to all lien holders. Also creates, this one's fun. It creates what the bill refers to as alternative lien holders, which the alternative lien holders, it's again intended to allow these preferred parties to purchase the lien. Who are the preferred lien holders? Well, the unit owner is the first one. So you foreclose a lien, you foreclose a unit owner out, and then after they're foreclosed out and they fail to pay for it, they're in first position as an alternative lien holder to seek to redeem on the property if they somehow come up with the money. How they get foreclosed out and then don't redeem or don't figure it out prior to the sale, and then after the sale they can come in after and be a first alternative lien holder. I'm not sure, but again, intended to keep people in their house. It also creates alternative lien holder or a tenant. If the unit is tenant occupied, the tenant can buy the property coming out of the foreclosure. Then the next one is a nonprofit that provides affordable housing. So again, it's intended to, if you have a nonprofit entity out there that somehow finds that it's flush with money and can buy these units, they can buy the unit. Then a cooperative to provide affordable housing. And then finally, a political subdivision within the state of Colorado can come in as the last alternative lien holder and buy these units and run with it. It also expands the time in which these alternative lien holders can redeem. So they have 35 days after all other lien holder positions expire. So essentially what this means is that you now have this really long period of time where you're not sure who the hell is going to own your unit or the unit in your community, and I don't know who you're going to send assessments to, because if it starts the foreclosure and the owner gets foreclosed out on day one, and then they have 30 days for all the other lien holders, and then the alternative lien holders have 35 more days, you've got this extended period of time in which you really don't know who the hell owns the unit. So it's going to be problematic to see how this runs through. Where will HB 24-1337 appear in Kiowa? If signed, it apparently is signed. Thanks, everybody. I swear to God, guys, I looked 6 o'clock this morning and it wasn't signed, or the website didn't show it was signed. But it creates this morass of you don't know who owns the unit, and it's going to slow things down, and investors are going to be less willing to bid. But again, it's going to achieve the goal theoretically of keeping the owner in that house for longer periods of time. And it's going to appear in section 209.5 is part of it. I can go ahead and I can check exactly where it is, and I'll get back to you at the end of it. But again, it goes into, well, I take it back. It's in section 316, 316.3, and 209.5, which is the collection policy. And the bottom line is, as with 2433, which modifies the collection process, it means you guys need a new collection policy. Congratulations. I'm so excited. Anyway, 24, 13, 30, 1233 modifies the collection process. It removes posting requirements. So you are no longer required to post the delinquency at the property. However, you must now, in addition to your certified mail, you must make contact by two of the following methods: a telephone call, and if they don't answer, you have to leave a message, a text message, and an email. So two of those three. You'll notice what is missing is U.S. mail. Regular U.S. mail is missing. All last year, I sat here and I stated to you, when you send the certified mail, just drop another envelope in the mail and send it, and it complies. You are absolutely no longer allowed to do that. Because U.S. mail has, in fact, been taken off the list of effective notice requirements. Now, I'm not saying don't do it, just expect it doesn't count. Next, as far as your telephone call, your text message, and your email, what's supposed to go in it? I quite frankly think that, well, I don't frankly think, I do think that the entire notice that you send, certified mail return receipt requested, which includes the delinquency, a statement that you must cure the delinquency within 30 days or legal action be taken against you, the name and phone number of a person with which you can discuss the delinquency with, and a breakdown of it, this notice requirement is in that exact same session. So when you call, and if somebody picks up, I think you have to sit there and say, do you have time for me to read you this very big letter and go through the entire letter? I think you have to read it. In your text message, I think you have to text the entire letter. If you call and leave an answer, or if you call and leave a message, your message must state what's in that letter. And I saw a question pop by with, did anyone consider the issues surrounding the CFPB? And my statement to your answer, Gary, is yeah, sort of, because what they say in the statute is that these contacts by the management company should not be considered to constitute a contact by a debt collector. However, yeah, federal law says exact opposite. This is an attempt to collect a debt, and this is a contact, and you have to comply with the Fair Debt Collection Practices Act at the federal level, and how you are going to get those two to comply together, I do not know. I don't envy you, because yeah, one violates the other. The only protection you would otherwise have is the statute says, this really isn't a contact. Okay, we're not going to run with that. Finally, at the very end of this, they realize that timeshares are still a different beast, and it excludes them. So if you manage timeshare, you don't have to worry about any of this crap. Can we still just do the posting on the door? Yeah, you can still do it, but it is no longer mandated, and it does not constitute one of these mechanisms upon which your collection policy must state this is how you contact people. If you want to continue to do the posting because it works, run with it. What options do you have if you don't have an owner telephone number or email address? I don't know. I hate to say it. I mean, the statute says that you shall do it this way if you have an email. So I guess if you don't have an email or if you don't have a phone number, you don't necessarily have to do this, but then you're going to be left wanting there will be questions as to why you didn't contact them, because remember, the whole point of this was additional contact. Okay. What if you don't have a phone number? As I mentioned, it's statute says if they provided one, so run with it. Any horror stories with the posting yet? I don't know. Everybody can tell you how how it's been going for them. I do know one manager was out posting on their own, and they ran up and posted and then ran away real quick and then tripped and fell in the grass and stained their pants. I thought it was pretty funny, but it's not necessarily a horror story. Sorry, my best friend manager. Okay, the declaration. This one is also kind of fun too, because I filed this one under, wow, I didn't really know there was a problem. But, and yes, Susan, that means you need to revise all the collection policies. Concerning exempting small limited purpose communities. Before, the limited purpose community exemption was, in fairness, somewhat confusing. And it was confusing because it starts with, for a community created before this date, these rules applies. The community created between this date and this date, some other rules apply. What SB 24021 did is it just said, look, if you are a small limited purpose community, we don't care when you were formed, you are a small limited purpose community, and this is how you're going to be governed. You are exempt from everything in Kiowa except for 105 through 107, which of course includes all these public policy stuffs that we were talking about. And then do we really have to revise the collection policy? Yes, you really have to revise your collection policies to reflect these changes. Guys, I didn't do this to you. I'm sorry. I really am. But this one also states that it requires the HOA information officer to go through all the declarations they have registered through DORA, or the Department of Regulatory Agencies, and identify those that are small expense limited purpose communities and inform them of such. But as I mentioned, this falls into, I really didn't know this was a problem because, one, I don't think it changes. Well, I know it's not going to change one iota is to the advice we give. And it is the advice we're going to give is still comply with Kiowa, because that's what judges want to see. You still have to have your collection policy. You are still subject to all the public policy stuff about solar, about heat pumps, EV vehicles. All of that still applies to you. So might as well just kind of at least adopt all your good governance policies. And what is considered a small limited purpose community? It's a community that is under 20 units, has no development rights, and your assessments are under or your assessments are under $400 a year. So it's either 20 units and no development rights, or under $400 a year total assessments. So that's what a small limited purpose community is. And if you have questions, please let me know. We'll take a real quick look at your declaration. Usually these are communities that are in rural communities that do nothing but property owner or landowner, road maintenance communities, that type of stuff. Or they are smaller communities of, like I said, under 20 units. Now, condominiums are never small limited purpose communities. Condominiums are always subject to the Colorado Common and Stony Act. This would be maybe townhomes, or definitely townhomes, the stuff that's kind of built in Denver, with big party walls, they may be 5-10 units along. They do not have to necessarily be in an association. So moving on. 24-1383 identifies who can sign a declaration or an amendment to the declaration that is still under declarant control. And this, my hint is it must be the property owner. This comes straight out of a lawsuit that this firm was involved with, where the developer was, for taxing purposes, I'm not sure what he was trying to accomplish, quite honestly, but he put the land in one unit's name, or one development entity's name, and then he had a real estate company selling the real estate, and that was a different company. And then he had another one that was doing development of the property. So we had a development company, a real estate company, and a land company. And quite frankly, I think he just forgot what company owned what. So it resulted in a huge lawsuit, many years of litigation, and a court of appeals came out and said, look, this was a bad developer, and since they're all really roughly the same people, we're going to say that's a harmless error, and we're just going to say whoever signed it is right. Well, the title company's kind of freaked out, and real estate bar kind of freaked out, saying, how can a non-owner sign a plat on behalf of anybody? So we now have an answer. They can't. Does this create more problems that it solves? Yeah, quite possibly. mostly because we still don't have a solution for a developer that fails to annex all the property into the community. We still don't have a solution for historic bad acts of the developer. But this does solve one problem. We now know that it must be the property owner or a property owner's designated person that signs the plat and the map. So we go from there. Declaration. These are the public policy type stuff. And SB 24-145, which again, it doesn't necessarily appear in the Colorado Common and Stonish Act. It appears in a different section in recorded instruments, but it does two things. One, it allows an owner or owners, an individual owner in a community with, say, maybe a voluntary association, or to record a document that will remove illegal provisions. And this is, as you may remember, way back in the day, early 40s, 50s, coming out of, some very discriminatory time in the country where we weren't really trying to be all that inclusive. There are declarations out there that state colored people can't live in the community. Colored people or people of color can only live in a guest house or a servant's house. You can't do certain things on the property. You can't sell it to a homosexual. You can't sell it based on this. Those documents, they still exist. Now, they are absolutely 100% unenforceable. And if you ever look at your title commitment to a piece of property, it's going to say, these are exempted from coverage, except to the extent they impact restrictions on race, religion, national origin, sex, familial status, disability, or the like. This takes it a step further. It comes up with a really pretty form, and it says, you owners, or you, if you live in a community without an association, you can just file this document and have it removed. And this one is SB 24-145. Hope it's assuming you're talking about this one. And all the SB and HB stands for is which house of the government it started in. It's either Senate bill or House bill. Senate bills will always be 3 letters. House bills will all, or 3 numbers. House bills will always be 4. So that being said, would age be included in here? Yeah, sure would. And it creates this fun little provision that states that an association can, on its own, if it's got some of these provisions, record this document to exclude or to remove these very provisions. So this is the only instance where Kiowa says the board cannot amend the declaration on its own. And now you've got another statute that says the board on its own can act to amend the declaration to remove these very, very specific provisions. Now, I would argue the drafting of the bill was a little bit problematic in that Kiowa says that to the extent any other bill enacted or now enacted or to be enacted or any other law now in existence or to be enacted by the state of Colorado, Kiowa controls, and Kiowa says you specifically can't do this. Now, this other bill not in Kiowa says you can, but for the most part, I think you would be very, very hard pressed to find any one of these provisions in a Kiowa community because Kiowa was enacted well after these provisions were declared illegal and unenforceable. So you're really not going to find any of these provisions in that, but they are still out there. So it's interesting to see that the legislature decided to go ahead and take a step and say, look, you can remove them formally. This is how it. And Mary, all these bills go into effect August 8th. So that being said, we'll move on just for fun. Okay, this is another public policy provision. And this is HB 24-1091, fire hardened building material. This is straight out of the Marshall fires. And this flat out says that an association may not, if you have a provision that in your community that regulates or prohibits fire hardened building materials, it is unenforceable. You must allow the construction of or fire hardened building materials to be installed on a home, an outbuilding, a roof, you name it. You have very little leeway in regulating this. You can kind of get into the aesthetics. I refer to it as the color. Because if you've got an existing building or a building that is coming in to be built, you must allow fire-hardened material, the hardy plank siding, the stone roofs. Can we deny certain building materials for roofing? No, not if it's if somebody comes in and says this is a fire-hardened building material and it's advertised as such pursuant to the building code, they can pretty much put it on. If your guidelines say it increases the cost or decreases the efficiency, no, you can't deny it. So it's going to be very problematic on this. Now, it's funny because then it goes into say you can adopt all this stuff if it's fire hardened material for fencing, but you can't do it for the home. But for fencing, yes. So can we deny building materials for roofing? I mean, probably not. Allowing class 4 shingles with a class fire resistant, but not allowing stone roofing. No, I think if somebody wants to throw stone roofing on, they probably can. So let me go make sure I've got kind of all these things, Yvonne, great. And then no, if you're amending the declaration under 24-145, it does not require a homeowner vote. That's the whole point. This can be a board vote on its own. Okay, can you restrict color on those materials, Angela? Yeah, probably. And you don't have to allow somebody to come in and do a bright pink building, but at the same time, if you've got a restriction says it must be neutral colors, and they come in with fire hardened building material with a neutral color, you're kind of stuck. You're going to have to allow it. And like I said, but this is also it's a very specific definition of where where these fire hardened materials can be found, and what are the not the dimensions, but what are the parameters upon which they can be discussed. So can you mandate fire hardened building material? No, probably not. They just have to be allowed. There you go, Beth. Okay, moving on. So we can get back to all these wonderful questions. Operation of home-based businesses. Again, this is post-COVID legislation. And the whole return to the office mandate, yeah, hold off. I don't think so. Buildings, commercial buildings are, struggling. And what this bill says is I can operate a business. If I own or occupy a unit in your community, I can operate a business from it. Now, traditionally, we have always said, if you are, if you are running a home-based business, as long as it doesn't have external manifestations of the business, you're fine. Who really cares? This allows some external manifestations of the business. You can't necessarily prohibit it just because I have customers coming in. You can't necessarily prohibit it just because I have employees working in my house. You can't prohibit it if I have a showroom. You can prohibit it. You can regulate the parking. You can say, okay, you customers go park over there. You can regulate it. The aesthetics of the home must remain the same. You also can prevent signage. You don't have to allow somebody to say Susie's Nails above the home, because that is, that's part of the other part of Kiowa. It says you can regulate commercial signage. However, if I want to set up a hairdresser in my house, I can. It still has to be my house, but I can put a couple things in there. You can run a pet vetting service in your backyard. Yeah, you sure probably can. It's a home-based business. As long as the pets aren't a nuisance. Yeah, why not? You can regulate the trash coming from the home. It's if they are creating extraordinary amounts of trash, all right, maybe you can assess another fee to it, but you can't prohibit it. And particularly if it's a single-family detached community or a single-family detached home and I pay for my own garbage. So this is one of those things that, again, they're making sure you, association, are not interfering with somebody's ability to make a business or make money, even if it's a side gig, in their unit, because they want to make sure, again, this comes back to housing stability. If I have the ability to live in my home and deal with that, go for it. And in answer to your question, does this apply to metro districts? That's a good question. And I stay, what about daycares? Connor, daycares are already protected. You can't prohibit daycares. But going back to the question, does this apply to metro districts? It is not in Title 32. All of these restrictions are found in Kiowa, 38-33.3-106.1065. But the legislature states, Kiowa states that this is against public policy. And as I mentioned, that public policy is Kiowa controls all other statutes in the state of Colorado. So if Kiowa says that this is against public policy to prevent it, it's going to apply to a metro district as well. Because again, this is the law that applies to community associations. And then can an HOA require following business permit rules? It's the business requires it. Can the association mandate a permit? Probably not, but the city can, because they can't operate a business without a permit. And if somebody wants to drop a dime on them, all right, I can't help that. Daycare and noise allowed? Yes, Irene. Daycares are protected. You can't touch them. That was last year's public policy statute. But they call it a business. Yes, Amanda. Daycares are businesses. But that last year's statute, again, that was last year, that daycares are specifically permitted, specifically protected by Kiowa. You cannot restrict them. So, regulate parking on the public right of way? No, John, you can't regulate parking on the public right of way. Sorry, if you can have all the people in the world park on the public street. What if the business creates unreasonable noise? Well, that's a nuisance. Repair shops out of a garage? Again, it still has to be a reasonable use, but it can have an external manifestation to some extent. What if they're running a business from the garage in a condo? Well, that's a common element, not the unit. A home-based business still needs to meet county requirements? Sure does. Are Airbnbs a home business? No. That is the ruling that came out of Houston v. Wilson Mesa Ranch. Airbnb is not a commercial use. The state of Colorado does not recognize Airbnb as a commercial use. Tylene, same answer. How can we prevent signage after the flag and sign bill? Because the flag and sign bill specifically stated commercial signage is not allowed. That's how. If the streets within our association are city owned, how can you regulate parking? You can't. What about the size of a sign? Richard, again, you can regulate signs or you can prohibit signs. Gail, what if we're pre as to daycare? Nope. The daycares apply to pre and post Kiowa. Jennifer, do you know whether HB 24-134 applies to short-term lodging? Nope, it is not. Short-term lodging is not a commercial use. Can I please repeat the Airbnb comment? Yes, the Airbnb is not a commercial use in the state of Colorado. Commercial properties go through a change of use and change of occupancy. Would you municipality then treat these commercial units? No, because again, it's a home-based business. It is not a commercial use. The property is not a commercial use. The property is still a residence. It just has this ancillary use as a business. All right. Rapid fire. Here we go. Moving on. This is more on public policy. SB 24005, non-functional turf. This applies to municipal entities and associations as to common areas. It does not apply to owners and their individual private yards yet. What it does is it allows only for functional turf grass to be located in cities, municipalities, HOA, common areas, and functional turf grass is essentially it's a recreational use area or other space that is reserved, regularly used for civic, community, or recreational purposes. It's soccer fields, it's baseball fields, it's a park, if you will. But if you have this large stretch of land or a large stretch of property that is nothing but turf grass and it's not regularly used for recreational purposes, you can't replace the grass if the grass dies. You must go to xeriscaping concepts. New projects coming out of the ground, the city may not allow grasses to be used or grasses to be installed on anything but, again, you can only have functional turf grass. It also prohibits artificial turf in a large number of these areas. because artificial turf creates a heat island. So again, it's one of those things that if you've got these big open spaces that are not parks and not designed as parks, you will no longer be allowed to maintain those as grass if that grass dies. You can maintain the grass, you just can't replace it. Courtyard lawns not publicly used for sports but are small. You know, Chris, that's a good question, because it doesn't say size. It says used for recreational use, and if it's not used for recreational use, you can't use grass in it if it's a common area. So I'm getting down, if that grass dies, you're probably not going to be allowed to replace it. No, you can't use fake grass. You must use other xeriscaping concepts. You got 40 acres of it. That should all be natural growth. This is that whole point. If you have Kentucky bluegrass sitting on 40 acres, you shouldn't be doing it. It should be non-irrigated areas like buffalo grass. This gets to, again, my friends, this gets to, they don't want the big lawn consuming yards. And if you got 40 acres, no, that should be something else. Because if you're irrigating 40 acres, I'm sure your association's going broke. Who defines recreational use? Well, the statute defines recreational use. It's a park. It's as I mentioned, it's used for civic or community or recreational purposes. Can native landscape areas, water tolerant landscape, still be irrigated? Yeah, to some extent. This is the grass. That's what they're getting at here. Tree lawns in Aurora. Oh, tree lawns in Aurora are gone. You cannot maintain, you will not be able to install a tree lawn moving forward. And if that lawn dies, you will not be able to replace it. This is actually, those tree lawns in Aurora, Gary, there were some of the driving factors on this. And medians, if you have grass medians and grass traffic islands, not anymore. I mean, like I said, you can maintain it, you just can't replace it. That the state has an all-out war on turf grass. And turf grass, you know, again, it's the water-sucking turf grass. So you must plant what in dead spots, grass spots? That's a good question. I mean, honestly, Pam, the statute just says you can't replace this grass. So can you do seed if it's a small area? Yeah, probably. If I was thinking that exact same thing, if you were to have an irrigation project, you come in and you plow up all your irrigation system, are you stuck with now xeriscaping where your lines went? It's the statute, you know, it's kind of all or nothing. And I think you're going to find out that this all or nothing really doesn't work, but we're going to find out. But it says you can't replace it. So we'll see how that plays out a little bit in the future. Okay, insurance. I file this under the too little too late category. The state of Colorado has created an insurance task force that's going to look at the problems with insurance. The good news is, like I said, it recognizes we have a problem. It's going to look at, you know, rates, admitted companies, why things are going up, how it's impacting community associations, how it's impacting owners. The bad news is the report's not even due back until January 1st, 2026. They've allocated $300,000+ to this to go out and interview the insurance companies, to go out and find out what's going on in the insurance land. And if the report's not due back until January 1st, 2026, now, tongue-in-cheek, I'll bite my tongue. I doubt they'll be able to do anything substantive in 2026, which means you're looking at early as 2027 with an effective date of 2028. Of course, we'll see what they do next year in 2025. But like I said, this report is not even due back for 18 months. So we'll see what happens to it. But there is no help coming on the horizon. And I wish I had a better answer for that one. Okay. Landowner liability, 24058. This is advertised as protections for private property owners. Really, it was geared at, you know, when the news came out that Governor Polis had signed this, it was that some of the tips or some of the summits of the 14ers are reopened to the public or could be reopened to the public because the landowner is now protected from liability, because a lot of the landowners, you know, shut off access to the summit of the 14ers because of the liability of people, you know, people hiking on private property. But again, what it states is it allows a property owner to post warning signs of dangers for recreation that are used for recreational purposes. It's very specific language on the sign, you know, what it has to do, and it can be put at the trailhead. So for some of you mountain communities, maybe people walk through your community to get to a trailhead, or maybe you've got some landscaping feature or some natural feature on your property that has become an attractive nuisance to the general public. You can now protect yourself from liability. Now, this is the pros and cons of this is, one, if you post something at the entry of your community, you're kind of inviting the public in as opposed to posting a no trespassing sign. But it will absolve you from liability if somebody gets hurt ice skating on your frozen pond, or swimming in your swimming hole, or hiking a trail that runs through your community. You can now at least protect yourself. But again, the double-edged sword with that is you're obviously inviting the public into your community. Okay, the Metro Districts. HB 24-1267 for you Metro District fans. This formally requires the association adopt an enforcement policy that is generally in compliance with HB 22-1137. It's not quite as restrictive, but if we represent the Metro District you work with, you probably already have this policy, because we've been advising this for years, and most law firms have been, is that a Metro District should adopt a policy anyway. It's what the courts want to see. It's what, you are enforcing what would otherwise be restrictive covenants through the auspices of an association. You just happen to be a Metro District. So this formally recognizes that Metro Districts that enforce covenants, they should have a policy too. So if you've already got one, don't worry about it. It's compliant. If you don't have one, you need one now. And then condo game area with bocce ball and horseshoe. Well, if you can get hurt, playing bocce ball and horseshoe and you open it to the public, yeah, you should probably post it there. The Corporate Transparency Act. I put this in there just for fun because, as you can see, yes, it is still a thing. Yes, you must comply. As of right now, this very second, there is no exemption for an association. For homeowner associations, FinCEN has flat out come out and stated that homeowner associations must comply. So by 12/31 of this year, you should absolutely have your boards register with FinCEN and upload their name, their address, a unique state identifying ID or federal identifying ID number, such as a driver's license number, state ID number, or passport number. You also have to have a picture of that form of ID. It must be done by 12/31/2024. Yes, in fact, it has been declared unconstitutional in Alabama. Yes, it is being appealed. Yes, CAI has in fact filed an amicus brief trying to get associations out of it. And we'll go from there. Irene, you have to register with FinCEN. If you Google Corporate Transparency Act registration requirements, it'll come up. It's like the top link. And it's FinCEN is the Financial Crimes Network, or it's money laundering. It's anti-money laundering board of it's the anti-money laundering entity through Homeland Security, and it's just type FinCEN or beneficial owners or Corporate Transparency Act. It will come up. And where's that law? Where's the law on that? If you go to altitude.law and hit the search bar and look for Corporate Transparency Act or CTA, it'll pull up a phenomenal blog that Alina Gilbert drafted, and it has all the links and all the information you need to know. And Gary, I'm available to act as a receiver for any board who finds themselves without officers because of the CTA. Gary, nice plug. If board members refuse to comply, resign, where does that leave the community? That's a really good question, Charlotte, because we have started to put into our bylaw template, and we're actually recommending you amend your bylaws to require compliance with the CTA to serve on the board. You can't have a board member refusing because they're not eligible to serve on the board, because it's federal law that mandates you register with FinCEN. So if somebody does not want to do that, they should resign from the board. And in answer to your question, where does that leave boards? Boy, I don't know. Again, we're trying our hardest, or CAI is trying their hardest to get you out, because it's hard enough to find a board member as it is. Can I touch base on the towing and monitoring? There was a new, Melissa, yes, there was a new towing bill that was passed. I didn't include it in this because every single one of the obligations in that was for a tow company to comply, not an association. So your tow company should, if you have a contract with the tow company, they should be the ones coming out and putting up the required signage, which is both in English and Spanish, is at least a certain size, has the international symbol for towing. It has to be placed as you enter into the parking garage and at other various locations within the parking lot that says they're subject to tow. You have to have the hours upon which they are subject to tow, or if it's authorized parking only, you must state that on your sign. The sign must be at least 3 and no greater than 10 feet high. And you cannot sign a contract that has indiscriminate towing, but rather every tow must be specifically authorized by the association. And then the owner has to submit towing requirements. But again, that didn't necessarily come out of this bill. But yeah, there are towing requirements, and your tow company is going to have to flat out teach you how to comply. So going there, we're being told we have to post the signage and tag. Is that not true? Well, you still have to tag, yes, unless it is authorized parking only. If somebody is parking in your community, no, you can instantly remove. If somebody's in your community parking inappropriately, no, you have to tag 2 times 72 hours, 24 hours apart each time. No. Does the association pay for the towing now? No, it does not. That part was removed from the statute. All right. Getting on to thoughts for the future by looking into the past. Again, I go through this every year. The last 3 sessions have included additional homeowner protections in the form of presumed damages for non-compliance with the statute, records charges, $500, xeriscaping, $500. Daycares were protected. Home-based businesses are protected. You're starting to see how the association's hands are, again, further being tied, and the theoretic power being taken away from the association. The task force is looking at homeowners' rights. The task force looked at homeowners' rights, delivered the report, came up with communication methods, and keeping people in their homes. That's what, as we mentioned at the very beginning, and more housing. The task force report identified what may be improved, while acknowledging that the majority of associations in Colorado are not facing communication issues because they do run well, and it's merely a handful of associations where there is a concern. That didn't stop the legislature from proposing fixes to what I call non-problems. Education was, of course, a key theme throughout the report at both the board level and the owner level. I have a hunch you are eventually going to see mandatory board member education. They identified minimum competency standards for managers. As you know, one of the bills that passed or did not pass this year, one of the bills that did not pass this year was manager licensing again. Representative Titone keeps introducing it. This year, it didn't even come out of committee. So we'll have to see if that was a major topic in the report. 231105, as you know, last year required mandatory ADR, or the task force was looking at mandatory ADR, some sort of reserve fund bill, licensure community managers, voter reform, and then communication reform. One of the things that was actually mentioned in the task force report was allowing an association to determine the best way to communicate with its owners for annual meetings and trying to get rid of the mandatory mailing requirement. Do I ever think there'll be community association managers to be licensed again? I would not expect it under a Governor Polis governorship. He vetoed the bill, and he is adamantly, apparently, against manager licensing, thinks there's better ways to accomplish it. Obviously, Representative Titone and Representative Ricks thinks otherwise. More results from 1105. Potential solutions include allowing lenders to escrow HOA fees, and therefore the HOA would be paid by the lender. Legislative Action Committee to create a fund to provide short-term assistance to homeowners in paying assessments. Statutory protection to homeowners' equity in the event of a foreclosure. Gets back to that homestead allowance, right? The very first question. Homeowner education being mandatory to buy into an association. More committees and persons. They want to form another committee of persons with differing interests who, quote, earnestly agree to work together to find solutions. Mandatory mediation prior to foreclosure, cap attorney's fees, that was done this year. Change 38-33.123, which is the attorney fee provision, from a shall be awarded to a may in relation to attorney's fees. Again, attorney's fees were addressed this year. Create a one-page Kiowa disclosure for purchasers and change notice requirements for monthly statements. Donald, they all go into effect this year, mostly August. Some of the other ones go back in a little bit later. So thank you so much, everybody. We ran right up against 1 o'clock. That is a problem with how I teach a class, is I get bogged down in the middle, but I prefer it. Thank you so much, everybody. Have a wonderful, wonderful day, and I will see you next year.